Tuesday, June 28th, 2022 meeting is now called to order. If you will, please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Madam Clerk, if you will, please conduct the roll call.
Banks, Collins, Tamayo,
Present.
Reyes,
Present.
Guy,
Present.
Akil,
Present.
Ingandela,
Present.
Valdez,
Present.
Irvin.
Present.
Let the record show all members of the Citizen Review Board are present with the exception of Reverend Banks and Dr. Collins. At this time, I will ask my Vice Chair, Colonel DJ Reyes, to read the meeting guideline.
Please silence all electronic devices. The duties and responsibilities of the Citizens Review Board are to review completed department investigations involving use of force and cases of importance and interest to the community or the city. Determine whether the disposition of reviewed cases was consistent with department policies and procedures. Review matters of importance or interest and make recommendations regarding the handling of these matters. Determine whether any revisions or additions to department policies and procedures are appropriate in reviewing matters of or importance or interest, and report findings and recommendations to the Mayor and Chief of Police. Cases that are brought before the Citizens Review Board are closed internal affairs cases that have been investigated and brought to the police chief for disposition. It is the Citizens Review Board's job to review the cases and render an opinion as to whether the investigation was done according to department policies and procedures. The Citizens Review Board members are provided the investigative files in advance of the meeting. The Citizens Review Board will hear from the department whenever matters of importance or interest are requested for review by the board or the department. The coordinator for the board is Captain Patrick Mesmer. Any person who wishes to make a complaint concerning a matter which may be considered by the Professional Standards Bureau should see Captain Mesmer for information on how to file a complaint. The board should not discuss matters where the city or the department may likely be a party in litigation.
Thank you, sir. We will now move on to the approval of the minutes from the meeting of May 24th, 2022. Are there any questions or provisions? Hearing none, I will need a motion and a second to approve the minutes.
Move to accept.
Second.
Board member Ms. Irene Guy has made a motion to accept approval of the minutes. Board member Tamayo has seconded the motion. Any further discussion? We will now continue with the vote. All in favor, please show by raise of hand. All opposed, please show by raise of hand. The motion passes. Thank you. We'll now continue with public comment. Are there any participants signed in for the public comment portion of this meeting?
No, there are not. Oh, wait, there's somebody outside right now.
There is someone here for a public comment.
Great. Did we receive any voicemail public comment for this portion of this meeting?
We did not receive any voicemail messages for public comment.
Did we receive any written comments for this public comment portion of this meeting?
We did not receive any written
There
comments
is
for
there is
public
somebody in
comment.
attendance, but they're not here for public comment.
Okay.
So there is no public comments. And just, Chair, just so you know, we've checked the phone messages. There were no phone messages either.
That would conclude the public comment portion of our meeting. We'll now continue with staff and board response to public comment. Being that there were any participants in the public comment portion of the meeting, we will continue with the agenda. Item number 7, items to be reviewed. Tonight, we are reviewing case 21F-001. I believe.
Hi, Corporal Janice, Assistant Public Affairs Unit. Captain Mesmer is out of town at a conference, but will be back next month. He was the captain who did the findings and disposition on this case, but I'll be reviewing it for him as I investigated it.
Okay, here we go.
And this is, like you said, 21F-001. On February 9th, 2021, Master Patrol Officer Lyon authored an email to his lieutenant expressing concern that his supervisor, Sergeant Anthony Portman, was destroying morale on the DUI squad and undermining former Chief Dugan's authority. Specifically, Officer Lyon alleged Sergeant Portman imposed quotas on members of the DUI squad and solicited photographs of the chief not wearing a mask. Officer Lyon submitted screenshots of text messages between members of the DUI squad, to include Sergeant Portman and Corporal Sims, involved in a conversation about a public letter written by the PBA regarding mask mandates. During this conversation, Corporal Sims sent a photograph of former Chief Dugan standing with someone dressed as Santa Claus while not wearing a mask, and suggested Chief Dugan should write himself up. Sergeant Portman replied, "Any more photos anyone has, please send them to me." According to Officer Lyon, Sergeant Portman related to his subordinates that he saw a staff member escorting civilians into TPD headquarters without wearing a mask, and that he should pull the video to give to his wife, who is our union president. Additionally, Sergeant Portman and Corporal Sims engaged in a conversation via their MDTs, which are the computers that they use in their patrol cars, about supervisors being seen on body-worn camera video not wearing masks, which Corporal Sims referred to them as elitist. Earlier in the conversation, Sergeant Portman discussed the existence of a photograph of staff members on a boat without masks on. Corporal Sims admitted to sending the photo of Chief Dugan and suggested that he write himself up, and explained the comment was made in jest because he knew Sergeant Portman was frustrated with the situation going on between the PBA and Chief Dugan at the time. Sergeant Portman admitted to soliciting the photos of anyone not wearing masks and stated that it was personal banter regarding former Chief Dugan's response to the PBA's letter. Sergeant Portman explained he felt former Chief Dugan may start coming after his officers and he wanted to protect them. Sergeant Portman admitted there was banter about obtaining video of staff not wearing masks. Regarding the alleged quota Sergeant Portman imposed on the DUI squad, Officer Lyon referenced an MDT message Sergeant Portman sent that read, 12 DUI nights should be easy. Officer Lyon suggested this quota could lead DUI officers to make bad arrests on marginal cases due to pressure that they felt from Sergeant Portman. Regarding the quota referenced by Officer Lyon, I obtained MDT records from the date in question, as well as the records from several dates prior to and after this message was sent. Sergeant Portman sent this message on Friday, February 5th, 2021, which was 2 nights before the Super Bowl being held in Tampa. This message was centered in a lengthier conversation about how busy it was that night and the need for the units on the squad to help each other out. When Sergeant Portman sent the message, Officer Lyon immediately replied, "Is that a quota?" Sergeant Portman replied, "No, you can't do 12 by yourself, and there will be Signal 1 all over the city." Signal 1 is our TPD 10 code for intoxicated drivers. The overwhelming consensus from all members of the DUI squad is that Sergeant Portman did not impose quotas, and that Sergeant Portman's comments regarding arrest numbers are meant to be motivational due to the squad's directed mission of DUI enforcement. The officers did not agree that there was an issue with morale on the squad, and some suggested it had improved since Sergeant Portman was transferred to the squad. In his final disposition, Captain Mesmer determined Sergeant Portman and Corporal Sims engaged in conversation with subordinate officers, criticizing the department's application of the mask policy, specifically seeking out and providing photographs of staff members not adhering to or enforcing mask-wearing requirements. This was done to obtain leverage, should it be needed, if the DUI officers received discipline for not wearing masks, and to mock their believed hypocrisy in the mask order. Sergeant Portman utilized the department's camera system to obtain photographs of a masked staff member accompanied by unmasked guests entering the TPD headquarters building. There was no legitimate business-related reason for Sergeant Portman to access the system for this reason, as it does not relate to his role as a DUI unit supervisor. Both Sergeant Portman and Corporal Sims utilized department-issued MDTs to engage in discussion and gossip. The actions of both Sergeant Portman and Corporal Sims did not reflect the proper leadership or guidance expected of a supervisor. Captain Mesmer found that based on the evidence provided, it does not appear Sergeant Portman or Corporal Sims' actions caused neglect or inadequate attention to their duties. Therefore, he did not sustain a violation of MOR 1204, attentiveness to duty. For both Sergeant Portman and Corporal Sims, he did sustain violations of MOR 1008, criticism and gossip, MOR 1402.02, departmental property restriction of use, and MOR 1701, supervisor. Corporal Sims did exercise his right to grieve the findings and the discipline in this case. He went to step 3 of the grievance process, at which time they did not sustain MOR 1701 supervisor. However, they did sustain departmental property restriction of use and MOR 1008 for criticism and gossip. His discipline was reduced from a letter of counseling to an oral admonishment. Sergeant Portman also exercised his right to grieve the findings. However, at step 3 of the grievance process, they maintained that all violations should be sustained, and his written reprimand also stated it, and they denied that grievance. If you have any questions about the case or investigation?
Thank you.
Corporal,
Mr. Tamayo.
Yes.
hi, Corporal.
Hi.
On the, on that stage 3 grievance, where they sustained all the violations, did that include the violation of 1204? Tentative
No.
to do, so that was already declined earlier?
Yes.
Okay, so that was not in play?
Yes.
Okay.
They just sustained the ones originally found by Captain Mesmer, the 3,
Okay.
for Sergeant Portman.
So the MDT system is basically the computers that are in all of our cars?
Yes.
TPD cars, okay.
Yes.
When these the texts that were being sent back and forth through, I guess, through the MDT, was this during on-duty hours?
Yes. That's the computer's where we get our dispatch calls. We run licenses, things like that. We use it for everything in the vehicle, and we can send messages back and forth, whether on a call or not, and it was during working hours.
Okay. I'm sorry, is it the Gentech or the Genetech?
Genetech system,
The
yes.
Genetech system. Can you describe that system? What?
It's the name of our camera system throughout all of our facilities, on all of our buildings. It's just the name of the camera system. But it has
Okay.
all the cameras outside of all of our districts, some downtown, and you can pull up and look in the hallways, look in the elevator, areas around the district, the lobby, the parking lots.
And can anyone on TPD decide to ask for footage of the Genetech system?
I know supervisors and detectives do have the access. I'm not sure if patrol officers do. I can find that out.
Sergeant
for you.
Portman did not?
Yes, he does have access to the system. I have access as a detective, but we use it for work-related purposes. Sometimes if someone's working a district office overnight, the only time I've ever really seen is they'll pull it up so they can see the rear of the building at night to see the entrance and exit, things like that.
And you would determine, Corporal, that this had nothing to do with his,
Right, he accessed
Duty.
the camera system, the breezeway, entering our garage into the main building, and there was no legitimate reason other than to look at what he thought he saw.
now, Major Mills was a subject of the Genetech video. Is he part of the chain of command with the DUI squad?
He was Sergeant Portman's major at the time.
So it's not by coincidence that he was selected
Right,
to
yes.
be viewed? Okay. Thank you.
If you will, Ms. Guy.
Hi. I'm just curious, are text messages containing personal banter allowed on the system?
No,
So not only were they talking smack, they shouldn't have been on it at all doing.
right. No,
Going
just
back and forth.
work-related, about the call that you're on, things like that.
Thank you.
Couple things.
Yes.
If you will, Mr. Valdez.
To clarify, one thing is said on the agenda, and then another thing is said on the grievance. So the criticism, was that sustained?
Yes.
Okay. How about the attentiveness to duty?
That was not sustained at the district level when it was investigated for either
Right.
the corporal or the sergeant.
Okay, and can you have an explanation as to why it wouldn't have been attentiveness to?
I didn't do the
sustained?
findings, I'm not sure. He said it didn't, the evidence does not show that they were negligent or paid inadequate attention to their duties. They were still operating as supervisors of the squad, so it didn't affect that part of their duties, is what was written in the disposition letter.
Okay, because according to what we received, the MOR attempting this duty, employees should not participate in any activity or personal business which could cause them to neglect or devote inadequate attention to their duties. By participating in all these other instances of text message and whatnot, that is clearly neglect of their attention to their current duties that they should be, attending to. So definitely, I feel like that should be something that should be sustained. And then thirdly, the supervisory, that's also not sustained.
That was sustained for Sergeant Portman and Corporal Sims at the district level when the findings were done. In the grievance process, it was sustained for Sergeant Portman and not for Corporal Sims.
I have no further questions.
Corporal, I'm sorry, if you had a, please.
If you
go
will,
ahead.
Colonel Reyes.
Thank you, Chair. A couple questions, Corporal. Thank you very much. Just for clarification for me, so in one of the statements, they talked about Officer Bannon having a series of low blow arrests. So let me just understand this. If I'm wrong, please correct me. Is that the situation where the person technically blows under the legal limit, so they would otherwise be legal, but then their other behavior in the discretionary judgment of the officer indicates they're still impaired?
Yes, that's the way it was explained to me. I think if you may have read the transcripts, I learned a little bit more about it throughout this investigation, that a low blow is anything under .08. And like you said, it could be narcotics, it could be another reason,
Right.
but they'll review it if they get a blow under the .08.
So I'm just curious, so if that's the case, and maybe there's another aggravating circumstance or something else going on other than the alcohol,
Right, it could be
When-
something else,
when they're
but they're
brought
showing
in,
other
then
indicators of
for the
intoxication.
veracity of that case, for that specific charge, that would impact on that, correct?
Well, they don't blow until they get to central breath testing if they elect to blow. So there are other indicators of intoxication prior to that. So they're still gonna get charged with it, but we don't know what'll happen at the end result.
Okay.
It could be a urinalysis, who knows? So, but they had other indicators to charge them with that.
Okay, thank you. And then the other question I have is on section 1008, the MOR 1008, it talks about the criticism and the gossip, and I understand that and the reasons why. But what about the situation where an officer has concerns, just like this officer that brought these concerns? 1008 says, you're not allowed to criticize per se. But then what about if that, in the mind of that officer, that person feels it's legitimate? There's something to that. What's their recourse then?
I think this officer handled it the right way. To the letter of it, it says publicly criticize or ridicule the department. So this officer didn't go out publicly screaming from the rooftops or anything that he thinks Sergeant Portman is doing this, Corporal Sims is doing this. He went through his chain of command. He's an officer. The concern was about his sergeant, so he skipped his sergeant's rank, went to his lieutenant, sent him an email and addressed his concerns. So that officer would not be alleged to have violated any MOR about criticism or gossip because he's addressing concerns through his chain of command.
Okay, and then as a policy question, internal policy question, do you have any kind of policies or practices where when you have these sort of situations, internal type situations, that you have like sensing sessions or informal counseling sessions where the team, in this case, the DUI team, would, under the chain of command, would get together in a setting, maybe an informal type of setting, to kind of discuss this kind of stuff so that it doesn't have to bubble to this point?
I've been a part of them before on squads when people just aren't gelling and we have concerns, things like that. And we do have the thing you're talking about, informal sessions where members of the squad will get together. If there's a couple that aren't getting along or they have concerns with the supervisors, without the supervisors, maybe with a shift commander, depending on the situation. I can't speak for Officer Lyon, but he must have felt that that wasn't appropriate and wanted to take it to the next level for this.
But would it have been Officer Lyons, would it have been, his discretion to actually request like a sensing session, or would that have been
yes.
the chain of command, Sergeant Portman?
No, he could do that if he thought, I'm for Officer Lyon, I don't want to speak for him, but maybe if he thought it was something that he could address with Sergeant Portman, Corporal Sims, and all get together, or just get together with the two of them and maybe the lieutenant, he could have elected to do that, yes.
Okay,
Yes.
thank you.
Yep, that's up to him.
If you will, Mr. Tamayo.
Corporal, you referenced the letter sent by the PBA. It was sent to the National Football League?
Yes, it was the one, I I just don't remember what publication it was in, but the PBA wrote a letter about, their stance on the mask mandates and things like that. And it was published, I can't remember, I'm sorry, where it was published, but Chief Dugan responded to it.
I'm just trying to get a sense of the context and the atmosphere within the department. How soon before, this happened in February?
Yes.
How soon before that was that letter sent to the NFL?
My recollection, it was within a few days.
Within a few
Yes,
days?
I'm trying to remember offhand. I don't know if Detective Gagny, do you remember? It was very soon after, within a few days, I want to say, because Chief Dugan responded to it. And it was when the Super Bowl, everything
Right,
was
so,
very close together.
and what was the nature of that letter?
I can't remember. I would have to go back and look. It was the PBA stance on enforcing mask mandates for officers. throughout
And the
city.
PBA stance was that the mask mandate should not be enforced on
I
all
don't
officers?
believe it was should not be enforced, and I don't want to misspeak, but Chief Dugan responded essentially saying that officers will abide by whatever policies are put out by the city, and if not, they could face discipline.
So that was the essence of the chief's response, that
Yes.
TPD was going to
Abide by
enforce.
whatever policies were put in place, any mandates, that his officers would follow those rules.
Okay, so at the time of these texts through the MDT system, the situation was somewhat hot.
It was 2020, early 2021, I think I can say it was a stressful, obviously we have officers that believe different things on both ends of the spectrum.
Right.
Sergeant Portman is married to our union president. I think a lot of things just came into play, that it was a tense situation.
And I just want to clarify for the record, though, that at the time that those texts were being sent back and forth, that DUI squad was on duty.
Yes.
And the subject of those texts had absolutely nothing to do.
I'm sorry, let me rephrase. The MDT ones, yes, were on duty. On the
Yes.
phone, the text messages, they were not on duty.
Okay,
They
but
were
the,
off.
but the MDT messages referencing having pictures
Yes,
sent was on duty.
yes.
And this is available for everyone within TPD, these
Yeah.
MDT?
They weren't sent to everyone at TPD. You can send a message just to one other officer, to your entire
Or like
squad.
within the squad?
Yes,
Right.
they were sent to, I don't remember exactly which ones. Some were sent between Sergeant Portman and Corporal Sims. Others included, I believe, one other officer.
But the range of people it was sent to was enough to give Sergeant Portman enough discomfort to say that we should stop these messages
Yes.
and meet at a restaurant somewhere.
Yes,
And again, this is on duty,
yes.
okay? I'll just read for the record, and obviously Corporal, you know this in your sleep. Attentiveness to duty. Department employees shall at all times be attentive to their assigned duties. And then what was also referenced, shall not participate in any activity or personal business which could cause them to neglect or devote inadequate attention to their duties. And again, this was a couple of nights before the Super Bowl, and I would assume that the DUI squads at that time are on high alert.
Yes.
For extensive driving while intoxicated, and there were MDT messages being sent back and forth within this unit that had nothing to do with their assigned duties.
Yes.
Thank you.
Very well, Dr. Collins.
Sorry I'm late, but this is a lot of reading.
Let the record show that Dr. Collins is available and present.
And I may have missed this, but because I read all this, I just want to know what it means. And thank you for asking, someone else asked one ago. What is HGN?
It's one of the DUI terms for the.
It's a horizontal gaze.
Step up here.
It's stands. I'm Detective Gagny. Stands for horizontal gaze and nystagmus. It's an indicator of DUI. It's basically you have to be a drug recognition expert to utilize this tactic, but it has to do with an involuntary twitching of the eyes. Yeah, have you ever seen where they use the pen and they say follow with your eyes? They're actually looking for horizontal
Gotcha.
gaze and nystagmus.
Okay, I just wanted to make sure. I got a couple other questions like that. There was reference to they holding the file of 3 years and they say, no, we didn't hold it for 3 years, how long are those files actually held?
I'm sorry, what files?
There was a reference to Brabant. He actually was concerned that perhaps they had held some files of his
Of
for
the
an
pending
extended period of
files?
time, yes.
Yes.
And he said they should have been discarded. What is the time limit on how long files can be held?
If you've had an evaluation, if it was just put into your file within a few weeks or months right before the evaluation, it will stay in your file and go to your next supervisor or remain in your file until your next evaluation. So a pending file serves as, prior to getting an LOC, if you commit a minor violation, maybe not even a violation, just something that you shouldn't do this again, we're gonna talk about this and address a training issue, things like that. They'll write what's called a pending file. So within 6 months, if you stay with the same squad and you don't commit the same infraction or training issue again, it'll be removed from your file. But if I received one maybe 2-3 weeks, a few months before I move on to a new squad, it'll remain in my file so that my next supervisor is aware of the issue. So Officer Brabant's concern is that Sergeant Portman was holding on to these pending files to use them against him at a later date. Sergeant Portman did provide documentation all the way up through the lieutenant that authorized him to hold on to these files to document other training issues.
Okay. And I only asked that because I understood that he was pulled off duty at some point, and he thought that it may have had something to do with the pending files that he felt should have been pulled.
Yes.
And not been held on for approximately 3 years. The question was asked about the MDT messages. When this come up again, I just kind of want to know what it is. That's why I asked about the HN. What does, and you just told us about the system. What does MDT, what
Mobile
does it
data
stand for?
terminal. Mobile data terminal. It's the
Okay.
computer that's in all of our patrol cars.
I think I got one more. Let's see. I think. You talked about the low blows, and thank you for that explanation. And what is DRE school? What kind of school is that they send them back to?
That's, I'm gonna refer to the detective, Jason DeGagny, who's my DUI expert. It's a drug recognition expert.
Far from, yes, it's a drug recognition expert, and I'm sorry, I did misspeak earlier. So the drug recognition expert is someone who can obviously recognize the different type of drugs that are out there. And in order to testify in HGN, which is horizontal gaze and nystagmus, you have to be a drug recognition expert. You have to take that class in order to testify. Officers, any officer can use that to detect the indicators of nystagmus. But again, you have to be the drug recognition expert to actually testify in court. So,
Okay. And you might want to just state my last question. HNT, I noticed it was under Officer Bailey's case, HNT. And the where it was sitting at that.
hostage negotiation team.
Thank you.
Yep.
Excuse me.
That's
And if you will, what is the letter of grievance and how is it used and what is its primary purpose?
If an officer feels that they disagree with the findings or discipline that has been administered by the department, they have the right through our contract to grieve it, and it'll go through different steps. Depending on the discipline that has been administered, it depends on what step it will begin. Sergeant Portman's in this case was a written reprimand, Corporal Sims and Sergeant Portman were both transferred off the DUI squad at the conclusion of this investigation. They both were put on patrol squads. Neither were happy with the findings or discipline, and they grieved them. So that's their chance to go through the process and explain why they feel it's unjust or unfair. They can suggest what they felt would have been a fair discipline, why they feel the findings are not consistent with department policies and procedures. So that's their way of appealing the decisions.
So to clarify,
If you're with Mr. Valdez.
the final outcome of disciplinary action was that they were put into patrol squad or was it reduced from a written to an oral reprimand? So not clear on that
Corporal
aspect.
Sims, his letter of counseling was reduced to an oral admonishment, and he was transferred from the DUI squad to a patrol squad. Sergeant Portman had a written reprimand. His grievance was denied, so that he had a written reprimand, and he was also transferred from the DUI squad to a patrol squad. And that takes into consideration the financial impact of being removed from a DUI squad. They work excessive amount of overtime, they get federal grant money to work DUIs, so that's taken into consideration to transfer them off the squad.
Thank you.
I've got a question on your oral or your written reprimand, your policy. Does that stay on the officer's record in perpetuity, or is it?
Yes.
So it's never removed at any time, to include the oral reprimand?
Correct.
Okay,
Yep.
thanks.
Oh, sorry.
You what,
Yes.
Mr. Irvin?
Yes. Do you know approximately how much of a financial impact the move for both of those officers were?
I don't want to estimate or misspeak. I know that they, like I said, they work, they have many opportunities for overtime, court, for all of the traffic hearings, things like that. It's a significant impact to their income.
Okay.
I don't want to misspeak and give you a wrong number, and I've never worked on the DUI squad.
Would that be, does the PBA, does the PBA consider that to be a additional punishment for those officers?
Not additional, but they know that it's taken into consideration. They understand that's why they're being transferred. It's part of the discipline.
Thank you.
Thank you. Mr. Tamayo?
Corporal, did Officer Lyon stay on the DUI squad?
He did.
Okay, oh, good. And still on it?
No, he had a formal investigation open subsequent to this as a result of something Sergeant Portman brought forward, and he was later transferred from the DUI squad for an unrelated issue to this.
Very interesting series of events, calls made as you were interviewing Sergeant Portman. A call made by a representative of the PBA
Yes,
accusing Officer Lyon of being a liar.
yes.
Can you,
I'm gonna ask, Attorney, can I go into the other formal investigation?
and this had to do possibly with the deleting of texts?
Yes, in this investigation, Sergeant Portman accused Officer Lyon of deleting text messages in the thread that he provided as his evidence, that Sergeant Portman felt changed the context and were relevant to the investigation. So after that, another formal investigation was opened on Officer Lyon.
That's what you just referenced?
Yes,
Okay.
yes.
Okay. I won't put you on the spot.
I understand.
Any further questions, statements, comments, concerns? You will, Ms. Sky?
A couple of my fellow board members have asked about the attentiveness to duty. And I think that maybe you can go into it a little bit more, because it isn't really, black and white when you're reading this. I mean, there are circumstances that you do look at that make it, qualify it to be used. So if you could just explain a little bit of that, I think it might help everybody understand.
I can't speak to Captain Mesmer's findings, but I just know that he wrote that from the evidence he was provided, he did not feel that Sergeant Portman and Corporal Sims were negligent, were inattentive to their responsibilities as DUI supervisors. He'll be back next month. He may be able to expand on that a little bit, but he just said based on the evidence provided, he didn't feel that was a charge that would meet what they did.
But it is evidential findings, because it's not cut and dry. Some of these others are kind of cut and dry. You did this, so
Right.
this happens.
Yes.
But with a case of attentiveness, you would have to have some proof that they were not attentive to their duties,
Exactly,
correct?
and Captain Mesmer reviewed all 12 extensive interviews and everything, and he just decided that it wasn't an appropriate allegation to
Thank
find
you.
sustained.
So the meeting that took place at the restaurant, which was on duty, would not declare attendance to duty?
No, we're allowed to have meal breaks, we're allowed to stop and get coffee, we're allowed to, depending on call volume, things like that.
So it was in the parameters of a
Right,
of a
it's just a
break
break.
or lunch or something of that nature. You would, Dr. Collins?
When they made reference to the inclement weather and they couldn't go out and do stops or was not gonna and it's two questions on this one. If they had stopped and that was duty time, and they indicated they was back behind somewhere, and then Portman kind of instructed them to get up and go back to work. If they were doing, let's say if Portman or one of Sims was there with them, and they were just sitting back talking about that, and because it was raining, would that be an attentiveness to duty? If they were all there, because he had them to get up and go back to work.
There would be a lot of factors taken into consideration when it comes to that, because we do stop sometimes at the end of the call to gather our paperwork or add things, notes to our computer, things like that. For the specific incident, it would be a case-by-case basis. I believe in the one you're describing, Sergeant Portman said that they were working on grant time, which means they were being paid to come in and specifically at a mission to enforce DUI, and they were sitting behind, I believe it was a restaurant, talking with their cars parked next to each other, and he felt that they didn't need to. They hadn't worked that many calls yet, they didn't have a lot of paperwork, and he felt they needed to go back to work and not sit and chat.
Okay, and then the last question that I have on this one, and it kind of around that, Matt, is there any kind of trendy information or data on the awards that went to TPD with Matt? You know, like, do they have an actual annual good record, you know, that they're doing that, where there is a perception that we can do this many cases?
I don't know about that, but I can find out for you. I know that it was explained to me in the interviews from the DUI officers that they are recognized if they get 100 DUI arrests a year, which apparently is very easy to do when your only mission is DUI enforcement. So during 2020, people weren't driving as much, people stayed home, and most of them, it sounded like at least half didn't make 100 arrests, so they were joking to each other that you weren't working, you weren't being productive this year, when in reality they understood that there were reasons why in 2020 people weren't driving and we didn't want close contact if we didn't have to, things like that. But I don't know about the data, I could try to find out.
Okay, that'll be just interesting if we could see any trendy data on how the record was, because they made reference to the COVID, and they also made records to the, Uber and Lyft.
Yes.
Where people were not
Rideshare.
driving as much, so as a result of that, the numbers may have been down.
Yes,
Okay.
It's a good thing.
yes.
Any further questions? Thank you, Corporal, for your turn.
Thank you.
Thank you.
Let's select this particular case to shine light on the importance of integrity and moral obligation our officer has to this department as well as the citizens. In this particular case, it raised a few eyebrows and was able to share with us the investigative streak and what should have taken place if an officer felt that there was something there in reference to investigative and the parameters and why they're there and why it's set. So with that being said, I'm open for a motion.
I would make a motion to agree with the process and the consequences. However, we would add the attentiveness to duty to the findings for the case.
Just to elaborate on the attentiveness duties that was not sustained.
Correct.
You're in agreement of it not
No,
being sustained.
Not being sustained, that's correct.
You believe that it should have been sustained?
Correct.
Okay, I was
Yes.
Kamari Pettis-Mackle from the City Attorney's Office. I was confused about, can you just explain, and again,
Sure.
it's, your parameters for your motion are concur, do not concur, or unable to reach a decision. And you can certainly bifurcate your motion if you concur with the determination, the disposition of the complaint, and you don't concur with the discipline, you can certainly bifurcate your motion.
Sure. So the motion is we concur with the process and the consequences. However, we do not concur with the fact that attentiveness to duty was not sustained.
I understand.
So your motion would be to concur with a violation of Regulation 1008, move to concur with the sustaining of the violation of Regulation 1402, and concur to with the sustaining of the violation of Regulation 1701. You do not concur with the not sustaining of the violation of Manual of Regulations 1204.
Correct.
Okay.
Second.
I have a motion on the floor by Member Valdez in reference to the sustain of violation 1008, 1402, 1701, and not concurring with MOR 1204. I have a second by Dr. Collins. Any further discussion?
Yes, so I would like to then ask again, just for my edification, the rationale behind the not agreeing with the not sustained for 1204, attentiveness to duty.
Sure. So as it states on the MOR, the parameters behind the MOR is that employees shall not participate in any activity or personal business which could cause them neglect or devote inadequate attention to their duties. So if they're busy, whether it's a minute, a second, whatever that is, they're not paying attention to their duties. Our officers are dealing with, life scenario issues that can, be catastrophic if somebody is just paying attention to a text message or gossiping about something that can put the lives of our community at jeopardy.
Okay.
And those concerns would be heightened at a time where the Tampa Police Department is on high alert for drivers while intoxicated, literally 2 days before a major event here in our city.
And thank you for that. And just to be clear, in Captain Mesmer's summary and his disposition, he didn't state any specific rationale behind his not sustaining 1204, correct? Did anybody see that? Other than him saying there wasn't sufficient, he didn't see sufficient grounds for 1204, and therefore it was not sustained?
And I'm gonna say, well, I didn't see it, if I'm right. The reason I second the motion is even if that one does not pass and the other three, we accept them and we bifurcated as indicated we could do. Also, it was stated that Captain Mesmer will be back in a week or two. And so perhaps if he could bring that one back to us with some explanation and give us more of the details, then we'll have the opportunity to move forward with that portion as
Okay.
well. And that was my justification for second the motion.
Okay, thank you. Thanks, Dr. Collins.
Any further discussion in reference to the motion that's on the floor? We'll now continue with the vote. All those in favor, please show by raise of hand. All those opposed, please show by raise of hand. The motion passes. Thank you. Even though the motion passes, make notation upon Captain Mesmer return, if we can receive some type of more elaboration in reference to why he did not sustain 1204 of case 21F-001, be greatly appreciated.
Can that be made as in the form of a motion to appear on the next agenda, please?
Chair is open to a motion for that to be placed on the next agenda.
Second.
Thank you. Is it necessary to vote on the motion that's on the floor?
Yes.
All those in favor of upon the return of Captain Mesmer to elaborate on the non-sustained of the MOR 1204 and have it placed on next month's agenda, please show by raise of hand. Any opposed, please show by raise of hand. The motion passes. Thank you. Well, now we'll continue with the agenda under Community and Tampa Police Department matters. If you will, Mike Schmidt.
We don't have anything for this month.
That was a fabulous report.
We'll now continue with the agenda under CRB staff reports and business. If you will, Ms. Kamara Pettis-Michael.
Good evening, board members. Kamaria Pettis-Michael from the City Attorney's Office. The board at the last meeting, May 24th meeting, made a motion to have a discussion regarding a pending city council motion regarding whether or not you as a board would like to have the ability to hire independent counsel and the ability to issue subpoenas. I put this on the agenda for the board to be able to discuss this as a whole, as a body. And at the end of your discussion, if you could just please make a motion regarding what the board's consensus is regarding this issue. I do want to draw to your attention the current code section that this board abides by is code section 18-8. Specifically 18-8 subsection H subsection 6 refers to hiring outside counsel, the ability of the city attorney's office to hire outside counsel when there is a conflict of interest. I could show that to the board, but it is what's currently in the code that you have, that the city attorney's office has the ability to engage outside counsel for the provision of legal advice to the CRB on matters of which such conflict of interest exists. So with that, the board is open to discussing this pending matter before city council. It is not scheduled yet for a date certain for that item to come back to for city council to discuss this pending motion. But I would like to have this motion in place so that when it does come back before city council, that motion will be able to be provided to city council.
Can I, city attorney, can I ask a question on that, or no?
Yes.
Could you give us an example a common example of a conflict of interest?
I don't want to go through a scenario when there could be a conflict of interest, but I guess if there is an item that's on the agenda that there would be a conflict, the city attorney would have the ability to hire outside counsel to stand in the shoes where I am, or to advise the board. That's if there is a conflict of interest.
I guess what I'm trying to understand is a conflict of interest is something from a personal or a professional perspective regarding you.
Right, because I am your current
Right.
advisor, so if I have a conflict of interest regarding a matter that's before this board, the city attorney has the ability through this code section to hire or, outside counsel to address or advise the board regarding that matter.
You will, Mr. Irvin.
Thank you, Mr. Chair. Why wouldn't they just select another attorney in the city's office?
I'm just outlining what's already in the code, but I understand, Mr. Irvin, what you're saying. Someone to cover someone else in the city attorney's office to cover.
Yes.
I just wanted to give the board this reference to the code section, but you as a board have the ability to discuss whether or not you would like to have the ability to hire outside counsel.
Dr. Collins.
Can you put that back on the screen, please? And while you're putting it back, let me ask, with the modification in our governing documents, is that something that has already been given?
I'm sorry, Dr. Collins, can you restate your question?
In the modification of our governing documents that we're currently under, this highlighted section that you have now, which was added in, does that afford us the opportunity, if there was a conflict with the CRB and the city, and we felt that the city and general attorney may not well serve the board, do we not already have that opportunity to do? And I'm asking that now because there's two things in here, and I want to go to the other one second. But right now, it's just on being able to hire outside attorney if there is a conflict of interest.
There is a current ability for the city attorney to hire outside counsel if there is a conflict of interest. That's currently in place, per the ordinance.
And so before I go to the second part of that, do we understand, did we hear anything? Was the city council able to discuss it at all so we can understand the rationale why that is now being added? Because I think the city council afforded us this opportunity. This is number 6 now that was not previously there.
It was, because city council approved this.
Right.
So city council was aware of this provision of the code. They approved the ordinance with that included.
Exactly. So my question was, do we have any understanding, or was there any discussion at city council why this was repeated to bring up again, and it is now pending at the city council level?
Oh, you mean regarding the regular issue, the issue overall of why is it pending? This was brought up to be included in the workshop to discuss, whether or not it was a motion made by a council member. And it was just whether or not the board wanted to have outside counsel. This is your first opportunity that you've had as a board to be able to discuss that as a board on whether or not you do want to have outside counsel. This is your first opportunity that we brought it up on the agenda for you to discuss.
If you will, Ms. Guy.
Thank you. Under section 18.8, that is our current.
Yes.
And the discussion with council, is there something changing that you would be the independent counsel? I know that was discussed before.
I cannot be, I am currently.
We would hire an independent counsel to do what you're doing.
Correct.
Is that what this is about?
Yes.
Okay, that's
Well,
my
that's
question.
what the pending motion is
Right,
before
okay,
city
I know it was a
council.
little confusing. We currently have the opportunity to have an independent counsel if we see there's a conflict. And the conflict could be not with you, but with the city. You know, if we were looking at something and the city had a different idea, I mean, there's all kinds of things that can be conflict of interest. But this, we currently have the opportunity. This is saying, and you can correct me if I'm wrong, that we would have independent counsel with us rather than a city attorney, and which I have heartburn with, by the way, spending city dollars to give us an independent counsel. We have the opportunity, if we see that there's a need, we can ask for an independent counsel. So this is changing that. Not the current statute we're under says that we have the opportunity to have an independent counsel if something is within our venue, we think we need it, or if you step
Correct.
forward and say, I think you need an independent counsel for this. So we have that opportunity already. So for me, this is a hard stop. Also, the ability to issue subpoenas is a hard stop for me. So I just got that out. Thanks.
Thank you, Ms. Guy. If you will, Mr. Irvin.
Thank you, Mr. Chair. So what is the process to get to the independent counsel procedure? We would ask you, regardless of the situation, because you stated earlier that your office or you would then go out and find or recommend or get the independent counsel.
So if it's the pleasure of the board with a motion approved to have outside counsel, we would first bring that back to city council to let city council know that it is the pleasure of the board to have independent counsel. There is a process in place to determine or, go through determine who could be your independent counsel. That's separate from the board, but there is a process in place in order to make that determination. But first, to address the motion that's pending before city council, we will report back that the board, if it's the board's pleasure to have independent counsel, it is the board's pleasure to have independent counsel. We will let city council know, and then we will go take steps to engage that independent counsel.
Now, I also would like to notate, this has been an ongoing issue, even during the developments of the current adopted addendum that we performed under. This topic has came up before, so there were several workshops, discussions, and things of that nature to get to where we are today. So as to piggyback off of what Dr. Collins mentioned, what was now different that we're readdressing or now having the opportunity after the horse is already carrying the carriage. so to speak. But opportunity is opportunity, so we can now take advantage. But obviously, our voice will have, you know, some meaning to it at this point where things change and things of that nature. So again, we are being blessed with the opportunity to open up a discussion in reference to how we see the board fit in moving forward if it's necessary, if there's a need. And if we can share that need today, then we can make a motion, not meaning that we will receive it or not, but at least we can move forward as a continued united voice.
Well, can I interject just one thing? The question is not whether we could sometime, at our pleasure, ask for an independent counsel. What's in front of council is that we would want an independent counsel to be here all the time in place of our city attorney. That is what is before the council. So that, I mean, that is, it gets a little confusing, and I don't want us to vote on something that we don't understand. Because we have city attorneys, they are our counsel for this board. What's in front of the city council right now is to remove them and have an independent counsel be our attorney. And I will interject, my opinion is that it's not necessary to do that. We have been served very well by the attorneys that we've had serving us from the very beginning, and I don't believe there was any incident that I can remember, and some of you have been on the board as long as I have, where we'd had a conflict with the attorney that was not, they had questions and they were answered, but that is really what the gist of this is about, having independent attorneys stand in front of us at our meetings.
And I think, to piggyback onto that was my innate comment, my innate concern, if you will, because I also felt that, at least organizationally, you have your role to play, and at least from where I'm sitting, I didn't see any conflict of interests, which is why it prompted me to ask you that question. Can you give us an idea of what do you mean by conflict of interest? Because quite honestly, I didn't see it. And I also agree with my board member here about fiscal responsibilities as well. I mean, there's no free lunches here. So we have to, you know, we're responsible stewards, and I think that's part of our responsibility as well. So I just wanted to share those comments.
Dr. Collins?
Okay. I'm gonna repeat it. What we have is what was just given to us, and it appears to be adequate. That's what I've been saying all along. My question is, I don't ever want us to turn down something that we may need. I know it surfaced in the community discussion when we were having all those community meetings and we had everything that was going on. But I don't know if the community knows or understand that as a result of their discussion, their intervention with the police chief and with the mayor, et cetera, when this new, I don't know whether we call it an ordinance or whatever.
Yeah, ordinance.
Okay, and I usually say our governance because I don't know what it's gonna actually be called. But when the new one was written and city council passed it and we brought new members on, it then afforded this board the opportunity to continue the relationship we've had with legal counsel from the city. And if we had a conflict of interest, if we had a disagreement that we couldn't come to together on, now we already have an option to go outside and get other counsel. That is correct?
According to the code section that I provided, the city attorney's office has the ability to hire outside counsel when the city attorney determines that there is a conflict of interest.
And that could be where the problem is, because I think this is saying if the CRB determines that there is a conflict of interest, and that's what we need to have clear.
It's whether the city attorney determines that there is a conflict of interest, the city attorney has the ability to hire outside counsel to advise the board.
Let me ask you this question, and I'm with you guys, because I don't think we need someone else to stand in here. We have good counsel. However, if for any reason this board has a difficult of opinion with the city or the city council, if we do not have the flexibility and freedom to make a motion and indicate that we want to get outside counsel, that could be what the issue is, and that could be what's up. And I don't know what it is pending, because when I asked last month, I'll ask again this month. It's up before the city council. They're going to discuss it. Do we have any idea why they're discussing it? And if the discussion is because we really do not have it, it's incumbent for us to understand that we can or we cannot. And it's in the, right now today, if we had a difference of opinion and we made a motion to bring in outside counsel, then we would give that to you and you would carry that back.
To the city attorney and to city council, because the ordinance will have to be changed. Because right now, the ordinance does not allow, it only allows this board or the city attorney to hire outside counsel when there's a conflict of interest. If it's the pleasure of this board to hire an outside independent counsel, period, to represent this board, then I would bring that back to city council and to the city attorney. We would start that process.
So my last comment on it, and then I'll hear some of the other board members. I'm not ready to make that kind of vote. I'm agreeing with other board members. However, I am concerned that the current ordinance that we have now does not allow this board to initiate that through legal counsel with the city. Because if the board really felt that, I don't think we need to have someone else sitting in here and somebody paying for it. I think we could use that money more wisely to do something else. But in the event a situation occurred and we felt we needed it, the board should be able to make a vote, pass that on to you, and then you go out and hire. And it seems to me that the board does not have that level of power, and that's what my concern is.
If I may just comment on that too, because I'm now really confused. It sounds like the current provisions is that it's the authority and the discretionary authority of the city attorney. What it sounds like, what our motion, proposed motion here is for us to decide that we want independent counsel. So there's like a step missing, that middle step to me. And the middle step would be that we would want the flexibility and the discretionary authority to, if the circumstances dictate, to request independent counsel. And I think that's, I can't speak for my fellow board members, but at least for me, that's the middle of the road of the spectrum that I could agree to, that we have the flexibility so that if the circumstances dictate it, we could vote on, hey, we need independent counsel.
Can you put the language up again?
If you will, yes, Mr. Irvin.
Thank you. So.
This right here?
Yes. So is that what we're currently operating under?
Correct.
Okay.
Mr. Tamayo?
Oh, I'm reading through this.
Yeah.
And no one up to now has found,
Go ahead.
please, go ahead.
So I heard a couple of things. One was that we would be making a decision as to replacing the city attorney with an independent counsel.
Correct.
And is that what is going before city council?
That's the pending motion before city council. And the pending motion specifically states that to prepare and present a draft ordinance that would give the Citizens Review Board discretion to hire or retain independent counsel.
To give the Citizens Review Board the
Yes.
discretion to hire, okay.
But if I'm not
Permanently
mistaken,
replacing the city attorney.
That, I can't go, this is the information that I have. I mean, to go on a case-by-case basis, I don't know how that would work.
So it would not be while a supposed conflict is in play.
It would be
permanent.
That's what this pending motion is.
That's a hard no.
Yeah, okay. Because it seems as if what we're operating under 6 allows us to go through you if we see a conflict through a motion to then ask them to hire an independent counsel for us.
They can decline that request.
Mr.
No,
Angadella?
well, the biggest thing.
Mr. Angadella?
I'm sorry, yeah, I think once we make that request to the city's attorney office, they could decline that request, right?
Are you saying under this current authority
Yes.
right here? This is for if the city attorney determines that there is a conflict of interest. So
Not
if
the
the city
CRB.
attorney
Right.
determines that there is not a conflict of interest, we would still be here provide advice to the board.
Sure, I just think that's what the apprehension is, that we wouldn't have that ability to go past a no from the city attorney, like if we didn't agree.
And-
So I think that's where the friction is.
So could you just say no, or would you have to take it to the city council?
I wouldn't, I would not be making that decision. The city attorney would be making that decision, whether or not there is a conflict of interest.
That the city attorney office sees
Right,
fit,
right.
not if we believe there's a conflict of
Right,
interest.
so
Only
if we made
they-
a motion, what I'm trying to discover is if we make a motion, what happens to that motion? Does the city attorney's office have the ability to review the motion and say no, or does it go to the city council?
City council, if it's the pleasure of this board to hire outside counsel, I would know that if the motion is made and approved this evening, I would know that, and I would be able to present that to city council. If that's the pleasure of the board.
Yeah, but that's for a permanent replacement, and we're looking at a case by case, I think, is what we're questioning.
If I may.
If you will, Mr.
So
Valdez.
if I'm understanding this correctly, based on what I read as well, and I appreciate you putting this on the agenda and having this discussion and hearing my fellow board members, I interpreted that the discussion for the workshop is to have the community vote on having the council or the board have an attorney, a private attorney. Is that accurate by what I read?
Say that
from the
one more
workshop?
time.
What I read regarding the workshop that was going to take regarding this topic was that they were going to have a discussion, the council was, in regards to the community voting on the matter as it relates to this topic, giving the community a form of voting when it comes to November 2 elections.
To be on the ballot, that was a part of the discussion, but most importantly, this board has not been able to discuss that matter, and this today is giving you the ability to provide your input regarding this pending motion.
Okay. I kind of lean to the other direction where I feel that we should have an independent attorney. With no, disrespect to our current attorneys, I know that you guys are doing a fabulous job, but we also need to take into consideration the pulse of the community. 80% of our community says that they are in agreement that we should have a private attorney. And part of our role is to be able to build trust within the community. And 80%, that data is coming from ACLU, an article that came out, and Creative Lofting that also put out an article on this matter. So I feel that in order to be able to work with the community and build that trust, we should be in alignment with them and be able to have that discussion and hopefully see it at the ballot and let the community decide whether they want to have it on the ballot for discussion or not. If you look at best practices throughout the nation, best practices have CRBs with private attorneys. So if we want to be part of that group that are providing best practices and services, I would recommend that'll be the direction that we head in.
Thank you, Mr. Valdez. I also like to state I had the opportunity to attend the 24th Nicole conference where I was able to speak with various members of different CRB communities. And what we determined is we have to create a board that works for Tampa's template. Obviously, different cities have different templates to meet their concerns. So I don't want to follow the common template, so to speak. This board was created for the city of Tampa. And again, I do agree with we must represent the community as well. I do not want us to mirror something that's happening down in Dane County or something that's happening in Atlanta, Georgia, because what's important is that we reflect the concerns of the people here in the city of Tampa.
And just to reiterate, 80% of the community feels like we should have one. So, but thank you.
80% of the Tampa community?
Correct.
And this is the poll that was conducted by the ACLU?
Correct.
With the, what kind of volume? How many people were polled? I just,
Yeah, I'm with you, sir. Can we see the polling data so we can kind of, do an assessment on it? Understanding the ACLU's lean.
In defense of Mr. Valdez, we do have scheduled, we have performed in the past our own community survey, and typically we take that data that we put a lot of energy and hours into, and we use that as our data and moving forward. And the past survey that we conducted, we've received a lot of various agendas from that particular data and set up our format and moving forward. So I'm not sure that we can continue discussion, but I'm not sure if we're going to be able to come to an agreement tonight in reference to this particular option. But we can continue.
Well,
Ms. Guy?
I would just have to say this. We are sitting up here, we have a lot of data, we kind of understand what's going on. What was the question on this poll? You know, do you think that the CRB should have a public attorney? A private attorney? I don't know what the poll said. And you know, I've worked with polling, and I can tell you polling is not always correct. It is based on how the question is asked and where you ask the question. So I would just caution you that it depends on what they ask. And a lot of people, I mean, if you weren't sitting here, would you really know? I mean, I wouldn't really have too much of a concept if they asked me that question. I would go, oh, that sounds like a great idea. You know, so I just would caution you with polls. I know everybody loves them. I ran for office. The poll said I was going to win. I lost. You know, so I mean, I know that polls can pretty much be manipulated to what they want them to say. So just caution you on that.
And in addition, this is a two-part questions or options, but we have yet to discuss the elephant in the room in reference to the ability to issue subpoenas. It's been an ongoing issue. It's been addressed on numerous occasions, but it seems to still manage its way on our agenda tonight. So this is something that I applaud that the opportunity is out there to hear the voice of the CRB. So let's address that, and let's either move forward with it or put it to rest. But obviously, by it appearing on our agenda tonight, there needs to be conclusion so we can move forward as a united front and get this issue off the table, with or without it.
My comment.
If you will, Mr. Urban.
Thank you, Mr. Chair. My question is for those more experienced board members. When have you seen the need to issue a subpoena?
Never.
That's important for me. Thank you.
But there's 3 other board members that have been here from the start. That would be my answer to the question.
Dr. Collins?
My biggest concern is that we do not want to send a negative message to the community that what they say that they think we need and we want, that we do not want it. At the same time, we do not want a message to the community that because they say we need it, we want it. I think it's clear for me to know what is pending on the city council's docket. When asked last month to have this discussion come up, so whenever it came up at the city council, we would have had an opportunity to discuss it. We didn't say we would make a decision. We wanted to have an opportunity to discuss it, and we've discussed it. And I think we see how we are all over the place, and I think we're all over the place because we don't know exactly, as you've indicated, what is pending on city council. It would be great if, one, we knew when city council was going to put this back on their agenda to give us adequate time. 2, we have a community meeting coming up. It'll be a good topic to have further discussion at the next meeting. And number 3, we may want to change, but it may not be what they're saying, because I don't want to see an independent council sitting in here costing the city money just to be sitting in here with us when we have adequate counsel now that's doing work for us. But that does not mean that if we needed to do it, is the only way we could go in the event there was I might be gone, all of us may be gone, and in 6, 7 years, there may be a need, and we would have closed the door for that need to be met. So I just think that we're not ready to make a decision because we don't have adequate information. I'd like to keep it on the agenda for next month's meeting, so that we don't just sit here and go ad nauseum. But I think this is a great opportunity for us to have and maybe to go back to those organizations and entities that we represent, encourage them to send information to us, to be at the next meeting, and to try to find out more than anything else, what is it that the city council had that they were going to bring up. And that other one, issuing subpoena, I've done the research on that some time ago, and I think I tried to do the top programs, and I brought it back here. And I know the difficulty it is for wearing out the subpoenas, but I personally don't think we are ready to take a vote, because I don't want us to say no to something that maybe we want to say, can we modify?
Dr. Collins, if I may, Mr. Chair,
Collins.
I've provided to this board the pending motion, the pending item before city council. There is, this is the pending motion before city council. There's no other information to provide regarding the motion. That is the motion. Whether or not this board wants to have the ability, discretion to hire or retain independent counsel. I don't know if you could give me specific information on what you're asking, what you're needing, what additional information you need from city council. I would have to
Rationale.
For starters, do we know when the expected vote on this particular motion?
I don't know when
I
I don't know when that workshop is going to be scheduled again.
Again, you said
Started.
discretion, which does not mean permanent, as I understand the language.
Well,
So,
we've been hearing that it does mean permanent.
Well, I don't, this is how this motion is pending before
Right, so-
city council.
So we need clarification on whether, in CRB's discretion, if we ask for independent counsel because we find a conflict of interest, whether the selection of an independent counsel makes that permanent. Under the current provision, it sounds like the
The city attorney would
right,
determine
right.
it because this
And-
board,
And the hiring of an independent counsel is only while that conflict is in play.
that's correct, because the city attorney has the ability to determine, and again, I'll pull up
Just leave it,
the city attorney.
because that's not looking so clear. It is.
So.
Rationale,
if we-
rationale.
If we can have clarity that if the CRB were to determine that it needs independent counsel because of a conflict, if that can only be while that conflict is in play.
Well, the question then is, how would this board know if there's a conflict of interest?
Oh, we would know.
That,
No,
We would not know the legal ramifications of what we were talking about.
We didn't say legal, it says a conflict of interest. If I was to ask right now for a question, and they go, oh, we just can't do that, and we keep
there are
asking. that's a
parameters,
conflict.
Dr. Collins, and just
If
to
you will,
clarify.
Ms. Guy?
It's in the event there's a conflict of interest as defined by state or city ethics law or the Florida bar rules.
And so you would have to tell us that.
I don't determine that, I don't determine, it says the city attorney
City
would.
attorney.
But I'm
would
just
make
saying,
that
you would have to
determination.
carry it, you would carry it back from us to the city attorney, and then the city attorney can make a decision. And if they made that decision and you brought it back to us the next month and say, no, according to Florida bar rules and the city ethic laws, that is a conflict, or that is not a conflict. And then this board should ask, can we bring an independent attorney or legal counsel in just to handle this issue? I know we got city council back then, I don't know, but if we can just get the city council to give us the rationale or some clarity on exactly what they're going to write, I know that's a pending motion, but we need a rationale behind the motion. I'm not prepared to vote it up or down. I'm not.
If you will,
Yeah.
Colonel Reyes.
Madam City Attorney, question for you on this conflict of interest. So you are our legal representative?
Yes.
Correct, okay. Who, in addition to us, who else do you represent legally?
Who are
The
my
city
other
attorney.
clients?
Right.
All of the land use boards, the Historic
Okay.
Preservation Board,
Right.
the Architectural Review Board, the Barrio
Okay.
Latino Board.
Okay, I understand.
I also assist with the Variance Review Board.
Right. Okay, so, very good. So I guess my more pointed question is, do you in any way, shape, form, or fashion represent the Tampa Police Department?
No, that's where
Correct. And
Mr.
so
Schmidt
what's
is.
the purpose of this board? What do? We are reviewing policies and procedures that directly impact or et cetera,
Right.
the Tampa Police Department.
Right.
But you don't have anything to do with any kind of representation with that.
Correct.
It's all the other folks that we're not really involved in. I'm just trying to understand, this whole conflict of interest thing keeps sticking in my head, and I'm just trying to understand why you're not appropriate in your position.
In the last ordinance, it was changed. That's why she's here.
Right.
That ordinance changed to.
Because
From
previously,
Mike Schmidt, but
Mr.
just-
Schmidt was
Understand.
your advisor.
Yes.
Now we're separating who
Right.
is providing guidance to this board. It's a separate person other than who represents
Which
the
just
Tampa.
based by its organizational construct,
Right.
you've just minimized
Conflict.
any conflict of interest, just purely by your position alone.
True,
I would agree.
true.
I mean, it's just an observation.
No, I would argue that if I'm going to sue you today for whatever reason,
Yeah.
and I say I'm going to sue you, but I'm going to give you the attorney to represent yourself. So the attorney is representing the same departments in the city where the police department and all the other entity represents, if that makes sense.
Right.
So being able to be in a position where an outside counsel can provide guidance and input to this board will be a sole neutral position versus a city entity body led by a police chief or led by the mayor. At the end of the day, the city attorney works for those individuals, so the representation is going to be in favor of the city mayor and chief of police, if that makes sense.
I don't agree
I understand it, but I don't necessarily agree.
So
with
there's
it.
been a lot of discussion, and correct me if I'm mistaken, but I believe at this point, is anyone willing to even make a motion in regards to, remember, two-part question, independent
Chair.
counsel and the ability
I'm willing,
to
but it won't pass.
issue.
Well, Chair, can I?
So in that case, if you will, Mr. Schmidt,
Yes, sir. Thank you, Chair. Mike Schmidt, and I've been here since this board was initially started. And, you know, as was said tonight, I am a legal advisor with the Tampa Police Department. I've had many roles within the city of Tampa. But when this board got started, as you know, Chair, you've been here too, and many of you have been since the beginning. When this board got started then and today, there is one thing that this board has always been. It is the Citizens Review Board for the Tampa Police Department. You guys have always provided a great service as far as reviewing policies. This has never been set up as a adversarial board. This has always been a board that's supposed to benefit the Tampa Police Department. As such, since the very beginning, I don't remember ever having any sort of adversarial relationship with the board. I don't ever remember anybody ever claiming that there was a conflict of interest with the board. Also, we've talked about subpoenas. There's never been a need for subpoenas. I think we've always shared anything that this board wants. We're gonna bring it back to you. You ask it, we're gonna figure out how to get it for you. I don't think there's ever been any sort of allegations that there has been any resistance by the department to provide you with information or any sort of conflict. However, as we know, for the last several years, there has been a lot of discussion in the public and before City Council about some alleged potential conflict of interest. Although it's never been established or shown, the City Council went ahead and changed the ordinance to allow a provision to make sure the city attorney had an attorney present, just to make sure that there wasn't any perceived conflict. Understood. Not that my representation ever was a conflict, to be clear, but we changed the perception by making sure that there was a city attorney who did not work within the Tampa Police Department or provide any advice to the Tampa Police Department. In addition, they added that provision that if there is a conflict, you could hire outside counsel. So we've already moved the ball considerably, even though there was no ever allegation of an actual conflict. The city has already done a substantial amount to alleviate potential concerns. Now, going to the engaging outside counsel, understand the way that it was set up currently is conflict of interest is defined by state or city ethics laws. Those have very clear guidance to follow. So we have an ethics code. Somebody owns a business. You can't lobby that business in front of city council. There are all sorts of lobbying provisions. There's all sorts of conflict of interest discussions in there about receiving money or maybe having dual roles or something like that. There is plenty of guidance in the city ethics laws and the state ethics laws. In addition, it says, or the Florida Bar rules. So there are also things that are conflicts of interest in the Florida Bar rules. So there is some guidance currently on what is considered a conflict of interest. If this board, and I would suggest the board consider a couple of things. One, the request city council has made before you. And if you stick with that, I think this might go a little easier. Simply answering to city council what they want to know, which is, if you look historically for the last 2 years, for several years, we know there's been voices who have said that there needs to be independent counsel. The question really before you is your chance to tell city council whether you agree. This is it. This is your chance. And I worry if you belabor it too much, if we string this out for 3 months, you may miss your chance, right? I would say this is a pretty simple question that you should know. And I gotta be honest, we've all known this for years. This isn't something new. We've all seen the media, we've all seen the coverage. The question is, do you want to ask city council for independent counsel for your board? If you want independent counsel, then this is your chance to say, dear board, we were requesting respectfully that you consider getting independent counsel for this board. Whether that's going to be done by ordinance or whether that has to be done by city charter, that'll be figured out in the future. But right now, we just want to know, by motion, does this board want to tell city council, we want independent counsel for this board? And if you do, let city council know. I think I'm a little concerned by overcomplicating this, because this could get dragged out for a long, long time, as we've seen it dragged out in front of the city for a long, long time. And I think I'm just suggesting that maybe you consider going ahead and attempting to answer this tonight, if whether or not you want independent counsel. I don't know it's that complicated of a question for this board. I hope it's not. And I'm just saying that as guidance, take it or leave it. That's it.
Okay. Mr. Schmidt, does city council support the ordinance as it is currently written?
I don't want to speak for city council, but obviously they passed it, right?
So the motion that we can have before us now is whether we approve with the ordinance as it has been read to us by Ms. Pettis-Mackle.
The motion really is, as we know, they passed the ordinance, right? With the thought that this was, the city came together, the mayor came together, there was all that, and they agreed to this ordinance as it is currently stated. There is still some discussions, though, whether or not there needs to be independent counsel. As Mr. Valdez says, there has been some public support for the idea that this board still needs independent counsel. And if that, you got to remember, the city attorney has explained to city council about her right to decide when to hire city council. I don't think the city's resistant to anything. The city and city council just want to know what your opinion is. They want to hear from you, because you're the board here who has counsel, and I think city council is just asking for your opinion. So they want to hear from you. Do you want independent counsel?
I'll make a motion.
Wait a minute.
Hold on.
Please.
You have a question? Any questions for Mike Smith before moving forward with any particular motion?
The question I have,
Dr. Collins?
Attorney Smith, is I hope simple. The pending motion currently before city council, would it remove what we currently have for council and go to an independent council across the board? Or would it be consistent with the current language and allow us to call for independent counsel when we need it because there have been a conflict of interest or a violation of any of those that you said?
I'm basing this off of the years that I've watched this matter come before city council and whether it needs to be in the charter and whether, I'm telling you the question before the board. Sometimes these motions don't get drafted as clear as the discussion really has been. I'm telling you with pretty certainty in my opinion here that what they want to know is, does this board want independent counsel, period? Outside and 100% independent counsel, meaning the city hires a separate attorney to sit before this board, to answer questions for this board, and that's what they want to know. It wouldn't be city staff anymore sitting here. It would be an independent outside counsel, not from the city attorney's office. That is what they want to know from you.
That's pretty.
Do we have that in writing?
I'm sorry,
That's
what?
that pen, we don't have in writing like we have with number 6. We don't have that pending order in writing, do we? I'm seeing
I'm
this
just-
council member back
No,
there.
I'm telling, we've read the motion several times, and I admit that there is a little provision here that we've said or retained, but I'm telling you, I've watched city council, I've seen that there was a proposal for a charter amendment on this issue. The real question they're trying to get at is, do you want independent counsel outside of the city attorney's office full-time? Now, if you want to.
Full-time, you just
Yes.
said it.
I'm
Full-time.
saying, like, you could also make several motions if you want. You could, in theory, make this as, I hate to say as complicated as you want, but, you know, first, vote on a motion. Do we want full-time independent counsel? Yes or no? Make that simple motion. Then, if somebody wants to make another motion, well, we want to recommend to them something else. That's your discretion. Anything you guys want to tell city council about this issue, I think this is your chance, but I would certainly at least address full-time independent counsel, because I think if you don't keep that motion simple and keep that vote clear, it's going to really muddy the waters. So I would suggest the very first motion is simply to decide, do you want full-time independent counsel, yes or no?
I'll make a
Now
motion.
you've added full-time for the first time, so that does clarify, yeah.
Well,
Full-time.
Mr. Valdez,
So I'll make a motion that the board recommends or agrees on having an independent counsel with the ability to issue subpoenas.
anyone want to second the motion?
So that motion failed.
The motion failed.
Okay, I'd like to make a motion.
Can you turn your microphone on?
I'd like to make a motion, Chair, that we decide tonight that we do not want an independent counsel. That's my motion.
Second.
Any further discussion on the motion on the floor to not have the ability to access independent counsel,
Chair,
full-time?
Chair, that was not my motion.
Okay.
My motion
Repeat
was
motion.
that this board would not have independent counsel, not changing the current ordinance.
And I second that.
And unreadiness.
Any further discussion?
Yes.
Again, the motion on the floor is to continue with the current ordinance and not changing from the current ordinance to independent counsel. And that motion has been seconded by Mr. Irvin.
Yeah. And I
Any
have
further discussion
further discussion.
upon the motion on the floor?
Upon the motion on the floor is suggesting that we want to stick with number 6 as listed currently, without having the option if a conflict of interest. We do have the option for a conflict of interest to bring independent counsel.
No,
But not by, no, she's saying to stick with what we already have.
The motion on the floor is to continue with the current ordinance. We can continue with the vote. Any other further discussion or questions in reference to the motion on the floor? Not meaning that that is we can add any additional motions, but at this moment, there is a motion on the floor. It has been seconded. Any discussion or question upon the motion that's on the floor?
Again, just for clarification, so the current ordinance allows it for a situation where there's a conflict of interest, but then we as a board would submit a motion or a request to the city attorney.
No,
It's the discretion of the city attorney.
No, I understand that. Oh, okay, so it's
Period.
not, we're not even, we
No.
don't even have the ability
No.
to
No, we
ask.
don't.
You have to decide. I got it, okay.
I mean,
Well-
if the board thinks that there's a conflict of interest regarding an item, and you want to make a motion for the city attorney to investigate hiring an independent counsel for a conflict of interest, I'm sure I could take that to the city attorney.
Yeah, okay.
But regarding a conflict of interest.
Right.
As a point
Okay.
on the motion.
Any further discussion or questions in reference to the motion that's on the floor?
One thing on the motion. I'm sorry, Ms. Secretary. We'll make sure that this is spelled out clear in the minutes so that in the event we come back to approve these minutes next month and there is any way we find something different, that this discussion, not all of it in detail, but a portion of this be clearly listed as to why this motion surfaced.
Well, I don't understand what you're saying, Dr. Collin. The purpose of the minutes is to summarize the meeting?
And I want this summarized, because oftentimes it's not the minutes, is we will discuss something and it will be listed without the rationale or the discussion that went along with it. And I just want to make sure that there's a sentence or two that clearly understand, because I'm under the impression we're going to stick with where we are now, with number 6 in our current ordinance, that we're then saying to the city council, no, we don't want any changes. And then the third big piece about that, we do not have clearly as a board, if we felt there was a conflict of interest, what we're saying we do not want now, and what we're passing on for those in the future, no opportunity to actually request.
We can submit a motion.
If it's the pleasure of the board, Dr. Collins, to make a motion at a meeting for the city attorney to consider whether or not there's a conflict of interest, we would take that to the city attorney to do that investigation. Again, I think Mr. Schmidt and I were trying to really simplify what's before, this topic to get this board to discuss it and make a motion, but there is a pending motion.
There's a pending motion. I do have a question about the pending motion. Does it also include the ability to issue subpoenas?
She's not addressed that in the
Not
motion.
addressing that,
Okay.
Any further discussion? We'll continue with the vote. All those in favor, please show by raise of hand. Any opposed, please show by raise of hand. Let the record show. The opposing members. That motion passes.
Can we get a count, please, for the minutes?
Well, are you saying a roll call vote?
No. We had a count. I just want the count put in the minutes.
Let the record show
I
that.
don't want it to appear that it was a unanimous vote or whatever. I'm
Right.
simply asking that in the minutes, we see a count. Not a roll call count. Doesn't have to say who voted how. I just want to see it was 10 for and 1 against, something like that.
6-2 in favor.
Now, I want to make a motion. Okay.
If you would, Dr. Collins.
I'm not going to bother with that. I'm going to leave that alone. It may come back next month before we approve it in the minutes. But I'm going to also ask that we do not deal with issuing a subpoena at this time, because if we have the same 30 minutes discussion that we just had, we'll be here for a while. And I still think we need to go and take a look at something on issuing subpoenas. I'm not particularly for it or against it, but I don't think we need to make a motion on that. And I'm asking that we not vote on that without the same deliberance or discussion that we had to the other.
Is that your motion?
You know what? I'm not going to force the board to vote on that. If they want to vote on it without discussing it, then let the board just vote on it without discussing it, and I'll do my, I'm not gonna put it in the form of a motion.
You're gonna remove the motion from the
No,
floor?
no, it wasn't a motion. I was asking, because we have not taken the time to discuss the board's ability to issue subpoenas the way we did with independent counsel, that we not discuss that one tonight. We moved that to the agenda to next month. So I'll make a motion that we table it for next month's meeting. Whether they get second or not.
There's a motion on the floor to table the discussion in reference to ability to issue subpoenas. Do I have a second?
Second.
Colonel Reyes has seconded the motion to table the discussion of the ability to issue subpoenas. Any questions or statements or discussions in reference to the motion on the floor? Hearing none, can we move forward with the vote in reference to the motion on the floor to table the discussion of the ability to issue subpoenas for next month's agenda? All those in favor, please show by raise of hand. Although opposed, please show by raise of hand.
You've got a tie vote.
We have a
so
tie vote.
We'll just, since it's a tie vote, we'll just, as a caution, just take it to the next agenda.
So the discussion under CRB staff reports and business, the discussion of the ability to issue subpoenas in reference to the pending motion that City Council has been tabled to next month's agenda.
Chairman, if I might,
Please.
I
Ms.
would
Guy?
also like to ask that before next meeting, that people make themselves familiar with what this is asking us to do. And I understand public comment, public feelings, but this, to me, is very serious, and I think we need to all be pretty clear on what this means to this board. So that would just be a request, that you all review what this means, what we would be putting ourselves under if this happens.
Is there some general legal documentation or reference that we can have access to that would basically explain, and would assist us in our overall knowledge of subpoena authorities and such?
That can also be forwarded through Ms.
Right.
Wilcox in adequate
To us.
inbox for members of the board to be able to review before next month's meeting. Would be greatly appreciated if there's any literature or any substantial in reference to the ability to issue subpoenas, pros or cons.
Might I suggest you Google citizens review boards and subpoena, because you'll get a whole lot of information, okay? I'm just suggesting that.
And it'll be all over the map.
And I submitted 18 different citizen review boards across the country about 5 years ago, I think, almost. And I'm sure that there are many more out there, and they tell you that most of them, when they don't get it, most of them do not start with it, and et cetera. And that is a good place to go Google and look at it. And I bought it here, and it was about 5 pages.
Okay, we'll continue with the agenda. Any items continued? There are no items continued. Continue with the agenda in reference to announcements and new business. The next meeting scheduled for July 26th of 2022 is scheduled at the Jan Platt Library, 3910 South Manhattan Avenue.
Mr. Chair, if I may, Kamari Pettis-Mackle from the City Attorney's Office.
Thank you, City.
I will provide like an announcement sheet, just like I did for public notice, that the meeting will take place at the Jan Platt Library. I will provide that public notice to the board, and the board can assist with spreading the word. But this is Councilman Carlson's district. I've been working with his legislative aide regarding scheduling this meeting. So I will work with I will work with her to also use that same public notice for Councilman Carlson to also disseminate or, spread the word that the meeting will take place at the Jan Platt Library. I just wanted everyone to know that. So I'll send you the public notice as soon as I get it done.
Okay, and will we get that within, maybe, will we get that early enough so we could get notice out there?
Yes, ma'am.
For media who tell us they needed 2 weeks'
Pardon?
notice? No, I was just saying for media who tell us they needed 2 weeks' notice, so we will have it.
I will
'Cause
make sure
you
to
send
get it
stuff in
done.
a timely fashion.
I will
Thank
make
you.
sure it gets done.
Okay, thank you.
I do, just if I can, Mr. Chair, I do have a signed, notice from the Tampa City Council regarding the 2021 annual report. It's a notice certifying that City Council received and reviewed the 2021 annual report. I just like to put that on the record and file it with the clerk.
Okay, thank you. Board members, if for any reason you're unable to attend the next meeting, please notify our city clerk, Ms. Tanya Wilcox, at least 48 hours in advance so we can ensure a voting forum. Before I adjourn this meeting, I would like to give any of our board members the opportunity to add any final comments or statements at this time. Mr. Valdez.
Are we doing anything with this document that you presented to us? Or is-
I'm sorry, thank you for reminding me. The email that I provided is an email that was sent to the Citizens Review Board email account. And it was sent after we had the meeting. So I wanted to print it out and to provide it. I don't know that you have to do anything. I'm just informing you that that was an email that was sent to the account.
Can we have it on the agenda for next meeting and we'll read it, and if there's anything that we don't have to discuss, we can just say we don't have nothing to discuss, or how can we go about, we want to discuss something? Because I don't know, we don't know what's on this, so if there's something, if it was addressed to us, whether it was meant for us or not.
No, it is meant for you.
Okay,
That's why
so
I
then-
provided it to you.
Thank you. So, yeah, I would definitely want to make sure this is on the agenda for next month's meeting, so that if we do have to talk or discuss anything, we have that time to do so.
Okay. Well,
Thank
is that a motion?
That is a motion.
Second,
So there's a motion on the floor to have the opportunity to review the material that was presented to us tonight and referenced in the CRB email account. We have a second. We'll continue with the vote. All those in favor of tabling such information to give you time to have this in next month's discussion, please show by raise of hand. All those opposed, please show by raise of hand. That motion passes. That material will be placed on the agenda for discussion of next month, July 26th, at the Jan Platt Library. Any other statements or comments from any of our other board members?
Mr. Chairman?
Mr. Tamayo.
Mr. Chairman, in light of the school shootings in Texas and other schools throughout the country, there's of course some public concern, anxiety, I'm sure, with many parents in the city of Tampa. I was wondering if we can have an update from the Tampa Police Department at our next meeting on what TPD's protocols are in our public schools concerning safety. The TPD presence in our public schools, the cooperation with the Hillsborough County school system. I know the sheriff's office, I'm sure, has jurisdiction over all the Hillsborough County schools outside of the city limits, but I'm assuming that the overwhelming majority of our Hillsborough County schools inside of Tampa are staffed with Tampa police officers. So if we could just have just an update on what the current protocols are for our parents before we start the next school year. That would be good to know at the end of the July meeting, sorry.
Thank you for that.
I definitely believe that is of community importance. I believe we can, if there's a second on that particular motion, it will be available under item 8, Community and Tampa Police Department Matters.
Just one more
Mr. Tamayo
thing.
has placed a motion on the floor. Did I get a second?
Yes, 3 of them.
I heard, I just didn't see it. Colonel Reyes has seconded the motion. Any questions? in
Just
reference the motion on
to,
the
not
floor?
questions, but I would also like to add to see if we can get data as it relates to gun incidents with the city of Tampa, to just have that information as well for next board meeting.
That's a big one.
That's different.
Yes.
Okay. Well, 10-4.
All those in favor, adding the protocol of prevention, in reference to, making our schools, safe for the upcoming, school term under item 8, Community and Town Police Department matters, please show by raising hand. Any opposed, please show by raising hand. That motion passes. Thank you, Mr. Tamayo.
Now, Mr.
Great
Valdez,
concern in reference to the
is
community.
your motion or is your motion regarding to schools or just gun violence in general?
In general, just statistics of, because it was 60 shootings have happened, or 60 crime-related or deaths have happened, like nothing, specific, but just number statistics as to where we are year to date.
That's why I asked for it to be separate from what Mr. Tamayo's motion was. So if you could just state your motion and then we'll go from there specifically. That is in general information.
Sure, so general information, I'll make a motion that we can have information as it relates to statistics and data on year to date, as it relates to gun violence, whether it's how many deaths we've had for the year, or how many crime or arm-related crime has occurred.
If you will, Ms. Guy.
I would like to add to your motion that it be put in maybe the August or the September meeting. This next meeting looks like it's going to be pretty full.
And I'm okay with that.
There's a motion on the floor in reference to a request to the Town Police Department to bring back data in reference to gun violence, year-to-date, and gun violence incidents. Anyone will second that motion?
I thought it was second. Yeah, okay.
Ms. Guy has seconded the motion
And this would be for the September meeting?
No,
Occurs
she wanted
for
it
the-
to August.
The August.
For August, okay.
for the August meeting. All those in favor, please show by raising of hand. Any opposed, please show by raising of hand. That motion passes to be placed on the August agenda
And then I have one.
with respect to Town Police Department being able to get that material in that timely fashion.
Thank you.
And I have one more question.
As you will, Dr. Collins.
We have an item that was supposed to be brought back, and I think, is it Captain Messner? And he was supposed to bring it back when he come, he'd asked us to delay it for 2 months. And since we've added all these on the agenda, I didn't bring my old notebook with me, I don't know what it is, but if that's gonna still be on the agenda, he's just coming back. If we need to modify that, I would indicate, Mr. Chair, if you could work with him on that item, whatever it
Yeah.
is.
So to recollect everyone's mind, it was information regarding the behavior discipline matrix that we discussed back in February, I want to say. So he was supposed to go do some research and provide us information with how does the behavior matrix correlate to what the department currently has.
Yeah, so my question is just asking to follow up, and if it's not, because he's just coming back and we have a heavy agenda, and you can determine what it needs. I'd like, if that's no more motions, I'd like to make an announcement before we close.
Well, and just regarding that, I make your agenda, so is it the pleasure of this board to have, what?
It was already a request, and I don't think there was a stipulation in reference to a deadline, with.
No, he asked us not to put it on this month, to wait next month to bring it back.
Next month.
Yeah.
You want it in
More
July?
of a
Yeah,
reminder?
yeah. And what we're saying is just work with him, and if it's too much, because it's getting to be a heavy agenda, yeah. Okay. But he did indicate he would bring it back to us, give him time to come back.
Because if we're too full, we're never going to have anything to talk about in September or October.
Yeah, we can definitely leave that for September, if needed.
Yeah,
to have
that's
that
what I was trying to say,
information,
so it don't be overwhelming, yes. And then I have one announcement, it's not a,
As you will, Dr. Collins.
yeah, this is June, so since it's June, I just want to make this announcement to us and to anyone else that hear it. This is Juneteenth, this is our first full holiday for Juneteenth, that was signed by President Biden on June 17th last year, so they had an opportunity. And the only reason I would really like to say this is everybody talks about Galveston, Texas, where the first announcement was made from the 1862 initiation to the 1865, June 19th. And I just like folks to know that we do live in Florida, and the official first announcement was made on May the 20th in 1865 by Brigadier General McLeod in Tallahassee, Florida, at the current Knox building, which had another name called Hapner or something like that. But the first announcement was made in Florida and not in Galveston, Texas. Happy Juneteenth.
Thank you. With that being said, this meeting is adjourned.